Everyone, good afternoon, and thank you once again for joining Achkar Law with our weekly webinar series. This is the Employment Law Essentials Employer Series. Thank you for joining. Today, we're going to be talking about crafting the effective performance improvement plan. Many of you know about performance improvement plans. It can be a scary topic, but Madison and I are here to shed light on it and provide a different framework for understanding them so that they're not so frightening. So a little bit about us. We are Achkar Law, founded back in 2016. Our focus has been employment law, human rights law, workplace investigations, labor law, civil litigation. We also have a commercial litigation group, and we serve all of Ontario. Today's podcast is going to be hosted by yours truly. My name is Charles Miller. I'm a senior associate here with the firm, and I'm joined by my friend and colleague, Madison Chilvers. She's also a senior associate joining me today. What is a performance improvement plan? As an employer, as an employee, you've likely heard this term, and it is typically a frightening one. Performance improvement plans are essentially a document that details that someone is either falling behind in their performance and what the employer expects them to do in order to get back on track to being successful. Many people think that if they're put in a performance improvement plan, they might as well start packing their bags, that the employer has every intention of terminating them. For an employee, if your employer wanted to terminate you, they could just do so. Performance improvement plans are not a tool for the employer to then show up and say, okay, it's time to terminate them. They failed the PIP. The performance improvement plan, or PIP, is specifically meant to bring an employee into a successful position. Specifically, it should be understood as a roadmap to success. And it's not just used to help employees who may be falling behind in their expectation to get back to being a talented employee again. Performance improvement plans are often also used if you want to determine if an employee is suitable for a promotion. You see, performance improvement plans should be understood not as a test to succeed or fail in keeping your job. Performance improvement plans are roadmaps to success, either from being a employee who's falling behind to being a successful one, or for an employee who's being earmarked for promotion. You see, having a really good sales associate, you might think, okay, it's time to put them into the next role, like a manager role. But the tools for succeeding as a sales associate are different than those as a manager. And even the best sales associate might not make an effective manager. And a performance improvement plan is your way to determine, will they succeed? Can I help them succeed? These PIPs are very important for developing and improving performance. And we're going to get into exactly how to craft that so that your company fosters just a and successful environment. Now, there's also some legal and compliance considerations for crafting a performance improvement plan that Madison is going to get into more detail later. Performance improvement plans shouldn't be just off the cuff. These are templates you should probably draft depending on the different roles or depending on the different areas. You might have a performance improvement plan for hitting key metrics as a manager or key metrics as a sales associate or some other role. And you might even have a performance improvement plan if you've got a toxic employee, as we've discussed in other webinar series, that you need to improve their demeanor or improve their workplace behavior. And because performance improvement plans can be tricky, it's good to have legal counsel work with you in crafting these so that they're compliant and good, because, and Madison will get into this, I'm not going to step on her toes and discuss it, but a performance improvement plan that is constructed poorly could do more harm than good. So when crafting your performance improvement plan, it's important to come at it from the framework of, this is a roadmap to success. This is how my employee is going to learn to go from good to great or from great to magnificent and help them succeed. And the way to do that is to be clear and specific about what they need to do to succeed. It's important not to use vague language or ambiguous terms. Be very clear. If you need your person to hit 5 or 10 calls every day in a certain role, write that in the performance improvement plan. Make it very clear what they need to do to succeed so that the employee knows. And if you've got a good employee, which I assume you did because you did a very good job hiring your employees, they want to succeed. Make it obvious and clear how to do that. If you have vague terms in there, they're going to be rudderless, not know what to do. It's important when you're setting these expectations as well that they are measurable and achievable. And I'm really going to emphasize achievable. If the employee thinks that this PIP is just completely nonsensical and there's no chance of achieving these goals, it can be determined to be an abusive document. Again, your performance improvement plan is a document. It's a written one. It's available for everybody to see. And if it looks like it's completely unfeasible, well, then you're going to have a problem. So make sure these goals are achievable and doable and easy to measure. It'll also make it easier for you to know if your employee is succeeding. Another element is the timeline. Performance improvement plans are finite documents. They don't last forever. In fact, if your performance improvement plan takes too long, it could be considered abusive. On average, most performance improvement plans are about 30 to 120 days, depending on the role. A relatively minor role might only take 30 days, whereas a more advanced role where it takes a little bit longer to determine if they've improved might take the 120 days. We strongly discourage going longer than that because it's very stressful for your employee to be in a performance improvement plan, even if you spell it out like this is a roadmap to success. So you don't want them to be on it for very long. So set the timelines and, more importantly, regular check-ins. We recommend that every 20 to 30 days, you check in with the employee. You come in with your rubric, your evaluation sheet, and you look at, have they started to hit these metrics? Again, you want them to hit it consistently. You want to know how they're doing. And so you can have regular check-ins. Have they improved? Has there been any improvement? Have they completely nailed the performance improvement plan? Great. Can they be consistent with it? Having these check-ins are great because it allows the employee to also know you care enough about them to make sure they're consistently succeeding and consistently doing well. You could also, as the employer, with these regular check-ins, find out if they're not succeeding and what needs to be done. Do we need more resources? Are there certain aspects that they're failing in? Or maybe you might identify that the problem employee is actually part of, it's not the employee's fault, it's the process getting to the employee. You need to really check in on that as well. These check-ins are great. It's great to keep your finger to the pulse on this. The last aspect of performance improvement plan is the most problematic or difficult or awkward one, and that's the consequences of performance improvement plan. These need to be clear. Everyone kind of knows that if you fail in a performance improvement plan and you're a struggling employee, that the employer will likely use as grounds for termination. You should make that obvious that this is something that is in consideration. I'll let Madison talk a little bit more about exactly how to craft that to keep your company safe and not vulnerable. But you need to make it clear so that it's not left at the open what could happen if they don't succeed in a performance improvement plan. And for those employees you have on it where they're considered for promotion, you should make it clear that if they don't hit these metrics, they will no longer be considered for that promotion. So setting the timelines, consequences, and the expectations, as well as the keys to success, truly make a performance improvement plan the roadmap to success, rather than just a test you give them. You find out later, 30 days or 120 days later, if they passed the test or failed the test. No, this is a roadmap. You're walking through them. You're the employer who cares about their success. It goes a long way to making your company healthy. And from a legal standpoint, if that employee were to bring a claim against you, if you can demonstrate this extraordinary good faith on your behalf, it sends a powerful message to everybody listening. We now know what makes a great performance improvement plan. How do we implement it? Well, as I said before, we want to be clear and concise, and so effective communication is the key. If you're going to put an employee in a performance improvement plan, they probably already know it's coming. I mentioned before that there's usually a progressive discipline approach when it comes to dealing with problematic employees. You'll have a verbal warning, maybe a written warning, then a performance improvement plan if they're still not hitting these targets. Well, even though they know it's coming, it's still important to talk to them about, hey, you're going on a performance improvement plan. Here are the metrics. We recommend having a face-to-face meeting either in person or over Zoom so they can have that human interaction when you're putting them on this. PIPs are very stressful, so be mindful and be kind when you're putting them on one. Touch base with them and walk them through very, very clearly exactly how they can succeed, what metrics you're hoping they're going to meet, and let them know exactly what's going to happen in terms of the timelines, the touch bases, or the consequences. It's important to also ensure fairness and transparency. That again goes through effective communication in terms of making sure that the performance improvement plan is clear and fair, and that it's very obvious to the employee why they're on it, how they can succeed on it, and when it will finish. Now, I mentioned before about touch points, every 20 to 30 days, depending on the length of the program. And it's good to provide some constructive feedback and ongoing support during this time. So if on one of the touch points you realize they're succeeding on some areas of the PIP and failing on others, tell them. You need to let them know. It's important not to just say, okay, I've evaluated, let's walk away. Let them know where they're falling short or where they're doing well. Especially let them know where they're doing well. PIPs are very stressful. Be kind to your employees. They go a long way with them as well. And then also with that, you can provide ongoing support. Get some feedback from the employee in terms of what they need in order to succeed. Also, we want to make sure you are monitoring the progress and documenting performance. Again, PIPs, although I keep saying use it as a roadmap to success or a pathway to success, it's still a document. It is still the employer you are following through and writing up and making sure everybody's succeeding. You are still going to need to keep your paperwork on this. Every time you have a touch base and you evaluate their performance, write it up, get it clear, and make sure that it's within the employee's files. You want to make sure that you are keeping your finger to the pulse on their progress, because you might need to adjust the PIP. Although PIPs typically will have a template depending on the role, depending on what needs to be improved, the needs of the business are not so strict. They're not so rigid. Business in this modern economy needs to be malleable and adjustable. And sometimes these performance metrics will change depending on where sales are going, or if while you're evaluating somebody, you realize that there's a whole process point. They might be one person on the chain of command that's only one part of the problem. So really, you might be insisting that they had to be evaluated on A, B, and C, and then you realize actually this employee is only really responsible for B and C. I need to talk to another employee about point A. You can adjust the PIP, and that's fine to do. If after a touch point you realize that some of these metrics aren't fair or aren't covering enough ground, it's fine to adjust it, but make sure it's clear why you're adjusting it, that you're adjusting it, and what the new measurements are, so the employee is always is never in the dark about what's going on. With these in mind, in terms of how to implement this PIP, what should go into the performance improvement plan, and how you should construct your mindset of it, you will set your employees up for success and you'll keep your company healthy. But there's more than just this element to consider when crafting a successful performance improvement plan. There's also legal implications. And for that end, I'm going to pass the baton over to my friend Madison, who's going to go into a little bit more detail about that before we dive into some questions. Madison, please take it away.
Thanks, Charlie. So Charlie did a really great job of addressing some of the key components of how to think about a PIP. Probably the biggest mischaracterization of a performance improvement plan is it's seen as some kind of tool to then justify terminating an employee for cause and not have to pay them notice. A PIP should not have the intention of being used as a tool to terminate that employee. It should be seen as an opportunity for the employer to set the stage for the employee to improve. It should be done in good faith, which is something Charlie has already touched on. And if it's found out that the intention of the employer was to use this as an excuse to terminate an employee for cause, you could open yourself up to additional damages. The PIP should be seen as a constructive and collaborative process. So it's not just a tool used by the employer to try and strong arm the employee. As Charlie said, it's really important to identify performance issues. What are the clear goals and the expectations? What is the support and resources that you're going to provide? Feedback, which is key. So Charlie again really highlighted this. Feedback is very key during the performance improvement plan process. And full transparency and honesty with respects to the PIP. That is going to help you as an employer eliminate some of the issues that may come up and result in an employee claiming what's called a constructive dismissal. So one of the biggest legal risks regarding PIPs is that depending on how it's implemented, depending on how it's drafted, an employee could interpret it as harassment. They could interpret it as creating a toxic work environment. And again, depending on the circumstances of how this is rolled out, which is why Charlie went into so much detail about how to properly roll out a PIP, they could have a claim for constructive dismissal. Now, constructive dismissal is not an express dismissal. When you usually hear dismissal, you think, oh, an employee's been told that they've been terminated. A constructive dismissal means due to the actions of the employer, the employer's breached a material term of the employment relationship or agreement, whether written or verbal, resulting in that and making it impossible for that employee to return to work. Toxic work environment is one of the more common grounds for a constructive dismissal. And again, depending on how a PIP is rolled out, could allow the court to interpret it in such a way that maybe it was a toxic work environment. You have to remember, as Charlie said, that a PIP is very stressful. It's stigmatizing, can cause a lot of stress. If it's found out between other employees, that employee could feel that other employees are looking down on them. Again, good to keep it confidential, keep it between you and the employee, and make sure you're coming into a PIP with the proper expectations that this is a roadmap to success, and not a tool to terminate the employee. One of the legal implications with PIPs is, depending on the circumstance of the employee, you want to make sure, one, you're not violating any other laws, including the Ontario Human Rights Code. A PIP is supposed to set out reasonable expectations that that employee has to meet. If, for instance, an employee cannot meet certain expectations because they have a disability and need an accommodation, but you put in a PIP that doesn't provide those accommodations but still expects that employee to reach that level, that could open you up to a potential claim of discrimination on disability under the Human Rights Code, which would be in addition to potential termination pay damages. If coming from the perspective that you're using a PIP because there's been performance issues, there is a substantial threshold that the courts have set to be able to terminate someone with cause as a result of performance issues. And just putting an employee on a performance improvement plan and then having them fail that performance improvement plan may not be enough to justify terminating an employee with cause. Generally, what a court would like to see is there's numerous warnings, disciplinary actions, letters, progressive discipline, PIPs. They want to see a genuine effort, and a PIP is a genuine effort for the employer to get that employee back on track. If that's your intention, and that's the genuine intention to act in good faith and try to bring the employee back up to the standard that the company wants that employee to be, your PIP shouldn't be able to be used as a tool against you as to a toxic work environment or discrimination, etc. So you really don't want to view a PIP as a tool of termination. You want to view it again as a roadmap to success. If after everything is fair and done and the PIP wasn't successful, they didn't meet the objectives, an employee could still be entitled to pay. With respects to performance issues, which is probably one of the more difficult areas to terminate an employee for cause or without notice, they could still be entitled to entitlements under the Employment Standards Act. They may not be entitled to common law reasonable notice, which is a different standard of pay upon termination, but they may not meet the threshold under the Employment Standards Act to be terminated without notice. And so unless you as a company can show that their conduct was willful, they were disobedient, willful neglect of duty, that hasn't been trivial and hasn't been condoned by the company, you may still have to pay an employee their minimum entitlements under the Employment Standards Act, but due to the progressive discipline and other measures you've taken, they may not be entitled to common law reasonable notice. To just wrap all this up, if you do have an employee who's having severe performance issues or you're putting them on a PIP for whatever reason, as Charlie said, it's really important to make sure you come talk to a lawyer and you're seeing what the PIP from all angles will look like. So make sure that there's no discriminatory elements if the case there's an employee who has a disability, or make sure that it's in line with policies that are already in line with that you have in place at the workplace. PIPs, again, the importance of writing, this should all be done in writing. Collaborative process, both employees and employers are encouraged to adjust the PIP. Employees, just because you get a PIP doesn't mean you need to sign it and agree with it right away. You can sit down, review it, give your version of events, and give your proposals to a PIP, because a PIP is, again, supposed to be a collaborative, constructive process to bring that employee back to the place where they were or should be to be successful in the company. Keeping a detailed employee file where you're recording all conversations, reporting emails. A lot of these conversations you're going to have about PIPs are going to probably be over meetings. You're going to write the details of the PIP down, have a meeting with the employee, go over the objectives of the PIP, go over what's expected, what the timelines are, and that's all going to be outlined. It's always good to do an email after that meeting to the employee, set the expectations, lay out the tone of the meeting, so that way you have a written record that not only protects you as a company, but again, if the employee, it's going to protect the employee in case they want to also put their understanding of that meeting on the record as well. Keeping a written record is extremely important when doling out PIPs or any kind of disciplinary measures to ensure that you protect yourself against potential constructive dismissal claims in the future.
Thank you so much, Matt, for taking us through the compliance legal aspect of it. We're now going to dive straight into our questions. We had a few that were submitted, and we have some in the Q&A. I'm going to start with the Q&A box there. So this is a specific one. How long should a PIP be crafted for a sales role?
So it's going to be very circumstantial. Remember, you want the PIP to be reasonable. You want the goal to be attainable. So depending on how long it should take that employee to reach that goal, that's how you should craft the PIP. You don't want to give a deadline on a PIP that wouldn't give that employee enough time to improve, because again, you open yourself up to that possibility that maybe that PIP wasn't actually meant to see the employee improve, but was used as a tool to terminate that employee.
Next question, what should I do if an employee refuses to go on a PIP?
Well, depending on the other circumstances leading up to the PIP, the first thought I have is what other disciplinary measures have been taken that's resulted you wanting to put the employee on the PIP. If the employee is uncooperative, that could be insubordination, that could be willful misconduct. Because if the intention of the PIP is, like I said, in good faith, it sets out clear expectations, clear goals, clear timelines, clear resources and support to be provided, that may give you grounds to terminate that employee, potentially for cause, again, depending on the circumstances. It is very circumstantial. So in that scenario, I would recommend maybe you reach out to us so we can review the circumstances with you, get a better understanding and help you devise some kind of action plan that will protect you as a company, but also address the issues you're having with this employee.
So next question, what should I do if I craft a 90-day PIP, but the employee succeeds after 30 or 40 days or meets the metrics after 30 or 40 days?
That's great. So feedback, if they exceeded expectations and met all the goals of the PIP and they continue that, they meet the goals, they continue to meet them after the 90 days, you can keep them on the PIP for 90 days, even though they've met all the goals, and keep giving them positive feedback and say that this is great, you're doing this and this, or you could end the PIP early if everything's worked out and you have no further concerns. It's, again, a PIP is a collaborative process, so you can talk to the employee. You can talk to the employee, you can be constructive about the feedback you're giving back. You can keep the employee on for the 90-day PIP if they have met all the expectations, and then they continue to meet them up until the end of the PIP, because the purpose is they're supposed to meet these goals and then continue to meet these goals, right? The PIP isn't just a temporary thing. So it's really up to your discretion on the relationship you have with the employee. And it's probably a good idea to talk to the employee, give some feedback, and figure out a plan forward with that employee.
So Charlie mentioned the PIP should be specific, but what if one metric is that the employee is too lean? Isn't that a little subjective?
This is where having a harassment, bullying policy in place at the company is going to come in really handy. And the reason Charlie's smiling is because in our last webinar, I really drove home having that policy, because now instead of saying the employee's too mean, you have specific sections in a policy you can point to that the standard that they need to meet, why they're not meeting, and what you want to see to get them to meet that standard. Because that policy is already put in place, they should know it. They should have a copy. Ideally, they should have signed it upon being employed with the company. So again, this kind of comes into the importance of having those types of policies in place. If you are lacking that type of policy, it may be worthwhile trying to get a policy in place. I think you may want to come talk to us depending on what the circumstances with this employee.
Is progressive discipline always necessary for terminating an employee?
No, depends on the circumstances. Obviously, if you have an employee in the workplace who is communicating racial remarks, for example, making it a very hostile work environment, that is going to likely result in a different course of action versus an employee who's tardy and showing up 3 days of the week late, and you've talked to them a couple of times. That would, to me, I would say do progressive discipline for that. Depending on the comments being made by this other employee or the severity of the conduct of that employee, progressive discipline may not be appropriate, because you also have an obligation to safeguard a work environment that's free from discrimination, harassment, and bullying. And if you have an employee who's overtly doing that, you also have an obligation to the rest of your employees.
Nice. What if an employee only partially succeeds on their PIP? Should I put them on another one, or do I have to let them go?
With respects to the legal complications when it comes to PIPs, a court will want to see that you as an employer have exercised all resources and all efforts to bring that employee up to the standard you want them to be. I don't know what stage this is at. For instance, if you haven't given them any prior warnings previously, if you haven't addressed their concern, if this is just like you saw the concerns, you put them on a PIP, I would suggest putting them on a second PIP if they didn't complete it. And you may also want to reevaluate your PIP. Was it reasonable? Did the expectations, the amount of time you gave them and the expectations, did that seem reasonable within the PIP and the circumstances? It's hard to say when you terminate them too. Depending on the circumstances, you may still have to pay them termination pay. It's not just an automatic, hey, you don't have to pay them any kind of termination pay or severance pay. So I would recommend you probably come talk to us so we can evaluate the circumstances with you and let you know what some of the risks are if you are considering termination.
Is there any evidentiary weight to a PIP that is performed randomly, like perhaps once a year, without follow-up feedback in terms of how effective those tend to be?
Okay, so I'm assuming you're using the PIP more as to assess the employee's work ethic or see what their performance is like in general, kind of a check-in with the employee. Maybe you're using it as potential promotions or bonuses. In that regard, I don't believe the best feedback would be if you were to do a PIP once a year and put an employee randomly on it and then do a performance review at the end of that year. That would be a good chance to get feedback. If you're not using the PIP because there's specific disciplinary measures, I'm not sure, or not disciplinary measures, but like performance issues, I'm not sure it would be necessary, because PIPs cause a lot of employee stress. And I don't know if you want to be creating that kind of work environment. But if you're tailoring it more as an assessment of their performance at the end of the year for bonuses, maybe there is a way you can do it, and maybe you shouldn't classify it as a performance improvement plan, because if there's nothing wrong with their performance, I don't know if you want to subject a good employee to something like that.
Very good. Outside of a workplace violence harassment policy, would a code of conduct also apply for a PIP as well?
Yeah, because it sets out standards that the workplace expects from its employees. And if they breach those standards, they need to improve their performance to come back to the employer standards.
Perfect. All right, everyone. And Madison, thank you so much for joining us today. As always, please reach out to us if you have any questions or comments or any ideas percolating there. We are more than happy to touch base with you. Thank you, Madison. And thank you to everyone who joined us today. Have a wonderful afternoon.
Have a good day, everyone.